Daily list for admission, item number 1.
May please your lordship. Am I audible, my lord?
Yes, who is appearing for 256?
Your lordship, I have submitted my power today for respondent number
Respondent number
7, your lordship.
7. Who is for the petitioner? You are. What's
My
it?
learned friend Bilaram Nemi is the learned counsel for the petitioner.
Okay. I wonder if she has something to say. She is not quite audible.
My lord,
Yes, go on, please.
I have the respondent number 2 is retired from his post, the chief engineer BRTF, and I have taken necessary steps. I have already delivered the order, so I'll be filing an application for employment of the new incumbent, chief engineer BRTF.
Okay, heard learned counsel for the petitioner. So and so enters appearance for. I think you appeared earlier for 2. You granted time to file so-called reply for respondent number 2.
Yes, Lordship, I'm appearing on behalf of respondent number 2.
Yes, you haven't filed.
Not yet, my lord. Since there's a new incumbent chief engineer.
And so learned counsel for respondent number 2 submits that a new incumbent has taken over from the earlier respondent number 2. Has it been implemented?
I'll be filing my employment application, my respondent number 2. Place of respondent.
That was way back 2003, order dated 2003-26. That is the day you submitted for respondent number 2. The day has been transferred out. Till date you have not submitted. Anybody appearing for 7?
Your lordship, today I have filed my power on behalf of 7.
7. So you are
Yes.
for now, you are for 7 and
4, your lordship.
4.
Yes. So may I seek, your lordship, may I seek at least 2 weeks time to file affidavit in this in the matter, your lordship.
Okay. On prayer of so learned counsel for the petitioner, on the prayer of learned counsel for and so who has entered appearance for respondents number 4 and 7. 2 weeks time is granted to file affidavit. Other parties, respondents may also file affidavit if not already filed. List again on so and so.
23rd June. Item number 2.
Your Lordship, I am appearing on behalf of Mrs. Vanesiami, learned counsel, who's the APP in this case, Your Lordship. Since the conducting counsel is in the other courtroom, Your Lordship, if this matter may be adjourned.
Who is for the petitioner? Nobody.
I'm appearing on behalf of the petitioner, my lord.
Yes. Why is it fixed for orders today?
Case diary has been called.
Case there is there.
Your Lordship, I am only a proxy today on behalf of Ms. Vannesyami. I am not informed.
So what is your prayer?
If Your Lordship, time may be granted, and if the matter may be listed again either next week, Your Lordship.
Already heard. Why is she not here now, today?
Your Lordship, she is on legs in the other courtroom. They have a hearing matter, Your Lordship.
But you can verify whether CD has been received or not. That information you could have had.
Your Lordship, if I may. Case diary has not been received, Your Lordship.
Right. Ms. Hard Learned Counsel for the petitioner, Ms. So appearing for Honorable Semi-Learned Edition LPP submits on instructions received that the CD has not been received as of now and prays for fixing the matter on another date. Hence, list the matter again on next Wednesday.
Much
10th
obliged,
June.
Lordship.
Obliged.
Item number 3.
May it please Your Lordship, I am appearing on behalf of the state respondents for the IA number 34/2026. Your Lordship, if I may be granted 2 weeks' time to file my objections, Your Lordship.
What is the IA for? Stay.
No, Your Lordship. Disbursement of money, Your Lordship.
Huh?
Disbursement of money, Your Lordship.
None appears for the petitioner in the IA. Okay. Ms. So appearing for all respondents.
Yes, Your Lordship. 1 to 3.
1, 2, 3. Please for some time to file objection. Hence, list the matter again after 2 weeks.
Much obliged, Your Lordship.
22nd June.
And the main appeal service is complete. Otherwise,
Your Lordship, for the main appeal, Your Lordship, for the main appeal, there's a separate counsel appearing for respondent number 1 to 3. I'm only appearing for the IA, Your Lordship.
too many respondents in the main appeal, but only 3 in the first IA.
May it please Your Lordship. My Lord, I was engaged to file RFA by the state. So I have filed RFA against order of attachment in execution case. So now after I filed RFA, I have also filed stay application. And my stay application was allowed. However, conditions has been made that some amount from the compensation award should be deposited to the executing court. Now I have already deposited the amount to the executing court. Now, all the respondents, the 42 respondents have filed this IA for disbursement of the amount that was deposited in the executing court. Now, since I was engaged only for filing this RFA, and it is, I was engaged by the state. So now the learned GA was engaged for filing objection in this IA.
But if you have deposited the money, then where is the question of objection for disbursement of the money?
Your Lordship, because the amount is, Your Lordship, for not only for only this case, Your Lordship, for other analogous cases as well. And Your Lordship, we will also specify and in detail about as to why we have a ground for objecting, Your Lordship.
This was this order for depositing was dated. That order was passed in the RFA. Well, no stay
I have
petition
filed a separate IA 193.
that has been disposed of.
Yes, my lord.
Order is you have the date of the order that I.
On 21 January of this year.
That is recorded in the order itself, disposing of the application that you have deposited. Now, what is the stage of the appeal? The appeal all have appeared. I think Mr. Lalthang Moya, he is appearing.
Yes, my lord. And before filing his objection in the appeal, he has filed his IA.
What objection is required to be filed in an appeal? Unless it's a cross objection. Alright, in the main appeal, you write none appears for the appellants. Sorry, Miss so and so appears for the appellants.
Which I
None,
also-
none appears for the respondents. It appears that the respondents were granted time to file objection, but by order dated 21/1/26, but till date no objection has been filed. The TCR has also been received. Hence, the appeal is ready for hearing. Hence, the appeal, which was admitted by order dated 28/10/25, is now ready for hearing. List the appeal for hearing on. Give a date after the vacations. So as far as this dispersal is concerned, no, give the same date. You want what, 2 weeks? So that will be before or after the vacations?
Your Lordship, if it is, it'll be more convenient after the vacations, Your Lordship, because there are analogous cases as well which are similar in nature to this
Okay, then
RFA.
give it date after the vacations in both. Okay, same date.
16 July.
Much obliged, Your
I think
Lordship.
this IA, by the time this IA is disposed of, the appeal will also be ready to be disposed of.
Yes, sir.
Supplementary list, item number 4.
Please, Your Lordship. Your Lordship, I would like to, before we start, I would like to extend my sincere apology because I was on legs yesterday and the Lordship time and my learned friend. So my sincere apologies.
Okay.
So, Your Lordship, I have
This is
contacted
which one?
the
This is item number
four.
4. Okay, Kaimul, Bormia Bail.
Yes.
Yes.
The question raised is whether section 47 and 48 is complied with or not. As far as section 47 is concerned, it is there in the records. And with regards to section 48,
Where is the
DNS says,
record?
my learned friend Daniel have submitted, I think.
This one. You are for the petitioner.
Yes, my lord.
Your ground is 47.
47 and 48, my lord.
47 and
my lord,
48. We have with us only 47.
47 is there. Your
Page
Lordship.
number 16, my lord. That is
With
the
regards
notice.
to 48, if I may take your lordship kind attention to the case diary, page number 3.
We may not have to go to 48. Your 47 itself is useless.
Yeah, I understand.
And what-
Even 48 is just written that arrest intimation were given to their relatives. That's it.
Yes.
So admittedly, it's a little bit.
Apparently, it has not. We cannot blame the IO or the arresting officer. These are small fry. What is your SP doing? When is he going to wake up and change the format?
Your lordship, I have spoken to them. I think I don't know because since this past few weeks, we have a lot of.
We will pass strictures
enlargement-
against the police administration. It is because of this that the people are criminals are getting scot free.
Yes. If that could be done, it will make substantial change, Your Lordship.
Where is 48?
There is no notice. There is
No
no,
notice.
no
There-
notice, my lord. It was merely mentioned that they informed their parents. But there is no proof. And my lord, with regard to section 47, my lord. So notice was issued, which is at page number 16 of the application, my lord. But in this notice, only the section under section 21C, 25 and 29 only indicated, my lord, that why I was arrested, the allegation against me is that I was escorting the involved vehicle. So I was driving another car. So that the reason for the arrest, why I was arrested, was not mentioned at all, my lord, which is at page number 16.
What is the length of detention now?
He was arrested on 27 January 2026.
I asked you the length, not the date.
Uh, uh, Almost 6 months, my lord.
5 months, 8 days.
Hmm?
Yes, Your Lordship.
Charge sheeted?
Non-charge sheet, my lord.
Not yet.
Not charge sheeted.
Non-charge sheet, my lord.
Was there any extension of the period?
No, my lord. No, there is no application filed before the Ilanit trial court for extension.
So what is the normal period?
Normal period is, my lord, 180 days, my lord.
So now it's around 140 days.
My lord. Around, yes. Now, 5 months.
27 January, so
Yes.
February, March, April, May. So 3, 4, 120 plus today is 8, 8, 19. So 130 days around. 30, 35, like that. So that part is not there. Okay, heard. Learned counsel for the petitioner and Mr. So and learned additional PP. This is an application under so and so. The paragraph 2 of the bail petition. The petitioner was arrested on 27/01/2026 and since then he has spent a period of, just calculate, okay, after today, days in custody. Para learned counsel for the petitioner submits that the notice under section 47 BNSS furnished to the petitioner is defective as it does not contain any grounds of arrest, thereby vitiating the arrest. Full stop. It is further submitted that no notice under section 48 has been served upon the family members stroke friend stroke nominated person of the arrested petitioner, comma, a fact which has not been refuted by the prosecution. A perusal of the extracts of the case diary produced by the prosecution does not contain any notice under section 48 BNSS. Para, I have perused the order dated 08/04/26 passed by the learned Special Court NDNPS Act ISOL, rejecting the bail application of the petitioner, wherein it is stated that the grounds of arrest and arrest intimation were duly furnished to the accused stroke petitioners in writing. But it is not known where from the learned court below came to the said finding. Full stop. A perusal of the notice under section 47 furnished along with the extract of the CD lends force to the submissions of learned counsel for the petitioner, inasmuch as the same does not contain any ground of arrest. Full stop. It is also to be noted that the format being used by the police of which is district is this Aizawl? Aizawl?
Khozol district, my lords.
Huh?
This is Ngopa PS case, and which is under Khozol district.
This is Nopa police station, Saitol district.
There is a separate district which is created recently, so it comes under Khozol district, my lords.
Then why have you stated respondent number 2 as Saitol district?
Your Lordship, it's under the jurisdiction of Saitwal district.
Saitwal.
SP is of Saitol only.
Yes, Your Lordship.
What did we say? Arresting officer does not contain any column for furnishing the grounds of arrest, although the law has been laid down long back regarding the necessity of furnishing the grounds of arrest in writing in Vihant Kumar versus State of Haryana, and give the citation, and even prior thereto. But however, it appears that the district police authorities have not yet woken up to the need to draw up a proper format under section 47 BNSS for furnishing the grounds of arrest. Full stop. Para. Comma, which has led to arrests in violation of the law laid down by the Honorable Apex Court, thereby resulting in release of the accused persons on technical grounds, even in case of serious offenses like the present one, which relates to recovery of commercial quantity of drugs, contraband drugs. Full stop. Para. In view of the above, comma, it is evident that the arrest of the petitioner has been rendered illegal due to non-furnishing of the grounds of arrest to the petitioner and to his relative stroke friend stroke nominated person, full stop, which entitles the petitioner to be released on bail. Para, it is accordingly directed that the petitioner so and so shall be released on bail of rupees 1 lakh with 2 sureties of like amount to the satisfaction of the learned special court in DPS, Aizawl district. It is further provided that the petitioner shall continue to cooperate with the investigation and shall not try to tamper with the evidence in any manner. Petition communicate a copy of this order to the Superintendent of Police, Saitwal District, Mizoram. What is to be done with this? This is a case diary, extract of case diary. This is a confidential document. The original is to be submitted. You want these photocopies to be lying around here?
Your Lordship, usually we don't, we can take it back. My learned friend can take it back. My learned friend Daniel is in the court only.
Return. Also return the extract of the CD to the learned additional PP. Yes.
Deeply obliged. Item number 5.
Will be there for the prosecution. You are appearing.
Shub, I'm okay. Yes, I'm okay.
Would it be possible to VC to conduct a hearing?
I don't know if Your Lordship is comfortable. I'm comfortable with it.
No, it's not a question of being comfortable, but whether you can place everything.
I think my citation has already been submitted.
He has submitted directly. Anyway, you continue. You haven't finished, have you?
Yes. Ours is item 27, part 2, my lords. My lords, we can continue.
No, she didn't start. So where is the question of continuing?
Yes.
Have you finished?
I have finished.
All right.
I'll just, my lords, at the end, point out just citations if it's required.
Oh. Yes.
Your Lordship, from what I gathered from my junior, even though I was not in the courtroom yesterday, I would just like to refresh so as to be precise that what I have taken as a stand is, first is time inconsistency. Second is Malkhana register not produced. Third is the witnesses are interested, some of the witnesses, prosecution witness are interest witness. And yes, is 2-3 counts on my ground. So before I started I would like to be sure on that. So if my learned friend can help me with that.
My lords, just 2 additional things, my lords. One is non-examination of a very material witness who is the magistrate who had certified the inventory. And also, my lords, there are 2 very particular documents missing. Rather, one, my lords, one is the test memo. One is the test memo and the very seal that was used at the time of seizure. And as per me, my lords, there is no seal. So there definitely no seal was exhibited. Therefore, my lords, the credibility of the seizure itself is highly doubtful. And my lords, that discrepancy we get to see from the bigger picture when there's a huge discrepancy in the sample which was sent and the samples which were extracted from the very weight of it. That's my.
Okay, so five grounds. So, Your Lordship, I would like to reply one by one. First, with regards to time inconsistency, if I may take your lordship kind attention to, my learned friend have stated that there is a time inconsistency because PW number 2 have stated in his examination in chief that uh, the cease, the place of occurrence, at the place of occurrence, the seizing took place at around 11:30 p.m. So it is written as 11:30 p.m. Now,
Okay, PM
this is-
part he has considered.
yes.
He admits it's AM.
Okay. So time consistency, I will not push that.
No, the inconsistency we see with regard to 11:30 and 10:30. Some PWs have said 10:30.
Yes,
And
yes, but
PW2 has said
they said-
11:30.
Yes, they said around, not at, so around. So if there is a huge deviation in the time, I could have understand. But then now could be now at this hearing, now we have this hearing, now it's 11:54. So after 2 years, maybe we can say that we have had this hearing at around 10:30 to 12, like that. So there's no huge deviation from that. So time inconsistency does not mean so much so as to make the prosecution's case weak in the case. So as for the time of the occurrence, it can be seen from the FIR and at the 313, page 3, question number 3 and 2. It happens at around 10:30 to somewhere about.
So it's they
11:30.
have not stated some exact precise time, but an approximate time.
Yes, around. It is written around, not at.
Okay. Next.
Okay. Next is interest witness. Now there are two independent witness, PW number 1 and PW number 2. Even though PW number 1, PW number 2 have stated that he have somewhere to go, and that even though he have witnessed the seizing, however, he did not witness the weighing and packaging. That's it. So there are two independent witness. The other witnesses are the case IO, etc., the seizing officer, etc. But there is no harm in that, because there is an individual independent witness. But anyhow, I would like to place a reliance on 2025 SC. Oh, sorry, it's 2025 SCC online 122.
Now, as far
I'll
as
start from-
PW1 is concerned, if he has left before the procedure is over, then how can you
When the
consider
seizing,
him?
Your Lordship, he witnessed the seizing. He was only absent when the weighing packaging was done. He have witnessed the time of entry, the time of seizure. But then since he have a conference that he have to attend, then he left and gave his signature at the home of the seizing officer.
My lords, this is precisely, I'm sorry, my lords, I have to interject, but precisely the point. NDPS cases, my lords, your lordships knows how important the time of seizure is. When weighing is done, when sealing is done of the packages, and it is seal is embossed on such packages, my lords, the independent witnesses are to sign on that at that specific time. I'm just pointing that out, my lords, and a test memo is made at that point in time. In this case, there's no
Your
test
Lordship, my
memo.
learned friend can submit his submission later, or he can finish it and I can continue.
Yes, go on.
And Your Lordship, with regards to interest
Which paragraph
witness,
of this? Raghuvanshi.
yes. Sorry, it's not.
This is regarding counsel's position.
Sorry, Your Lordship. It's 2025 SCC online SC 2866. Yes. Paragraph 13.
Yes.
It is a well-settled law that merely because the witness is an interested or related witness, his/her deposition cannot be disregarded. Other deposition of such witness is required to be scrutinized closely. That is the law. That is the principle that we have to adopt. Now, with regards to all the documents, with the
Interested witness, he is not an interested witness. So
No, Your
where is the
Lordship,
question?
my learned, it is the case of my learned friend that other witnesses apart from PW number 1 and 2 are interested witness. Since they are from the police. It is the case of my learned friend that...
PW3 is not independent.
Yes. PW number 1 and 2 are independent. PW number 3
Oh, acha, I
is...
thought you were submitting some decision on this point that whether Caesar witness should be present at the time of signing.
No, Your Lordship. Caesar witness, at least one witness is present in the whole process.
PW2.
Yes. There are two independent witness. One have admittedly not witnessed the weighing and packaging. However, the seizing and the taking out of the seized articles from the trunk, he have witnessed.
That is what
But-
is evidenced by the seizure list. That is why we have a seizure list. Because
Yes.
you have witnessed it in attestation of the fact of that recovery. This seizure list is prepared, wherein the signature of the witness is required. Now, if
Yes.
that seizure he is not present at the time of signing of the preparation of the seizure list, then that goes.
Yes,
All is left is
however,
his
we
oral
cannot-
evidence.
However, we cannot trash out the other independent witness.
He goes back for some business of his own and comes back and goes to the seizing officer's house and then signs a document prepared in his absence. Can we say
Correct,
he is a
admitted,
witness to that
admitted.
document?
Your Lordship,
Yes.
with regards to that, even if Your Lordship is not taking into consideration his evidence in toto, but then as what I have submitted here also, Your Lordship, I think that in my humble opinion, his evidence should not be completely outcast just because of that, to the portion only. However, he have witnessed the seizure of the articles, illicit articles.
Then he is to be treated like a normal witness, not a seizure witness.
Yes, normal witness, fine. However, if he is treated with the normal witness, then there is still one seizure witness. And whatever have stated by the independent witness or the seizure witness, then it still corroborates with the case of the prosecution,
Yes.
which is not shaken in the cross-examination also. And Your Lordship, that is with regards to interest witness. And number 3 is Malkhana register not produced.
So if you treat him as a normal witness and not as a seizure witness, then you are not in compliance with section 100 CRPC.
But that is, Your
Anyway,
Lordship,
yes,
I'm not,
go on. We'll take.
yes, I'm not
we have
treating him as
understood
a,
your point.
I'm not treating him as a separate witness. However, if that should be, I'll leave it up to Your Lordship. And third is non-production of Malkhana register. With regards to non-production of Malkhana register, Your Lordship, PW number 4, in her cross-examination, which is in page number 25, para number 4,
Yes.
she have stated, this is the cross-examination by the learned counsel for the defense. She have stated that it was placed in Malkhana. Even though register was not produced, but it was adduced in evidence before the learned trial court that it was deposited in the Malkhana. And then this was not shaken or cross-examined or before the learned trial court. And also, Your Lordship, if I may take Your Lordship kind attention to page number 20. 20.
Yes. PW4's deposition.
Yes, Your Lordship. Here, there's a list of exhibits. Exhibit M1 in the last line.
M1 seized article.
Yes. Yes, M1 is seized articles. So with regards to non-production of Malkhana register and my learned friend, another ground that the test memo is missing, then we can see from here that the seized articles was exhibited before the learned trial court for sampling. And it was produced before the learned trial court. And when cross-examination at the time of defense, which is cross-examination, which is in page 21, nothing as such so as to shake the credibility of the prosecution was not done, so as to doubt the test memo, etc., and the whereabouts of the seized articles. Now, in many cases, coupled with the other evidence, if there is cogent evidence of the prosecution that Malkhana the seized articles is produced before the learned trial court, or it is deposited in the Malkhana, then just because Malkhana register is not produced before the learned trial court is not fatal to the case of the prosecution, Your Lordship. In this regard, Your Lordship, this is not reported in SCC. I would like to place my reliance on State of Orissa versus SS Kanungo that was decided in 2002.
Achha, it's not supplied. Yeah, give the citation again.
Your Lordship, it is not reported. I think the printout is given by my learned friend.
I think he's still trying to find it.
Oh, I have requested him to print it out.
That's between you and him.
Anyway, what is written, Your Lordship, is that it's State of Orissa versus Sitansu Shekhar Kanungo, decided on 17th September 2002, wherein the Apex Court have held that none.
Where did you get that printout for? Which site?
It's from Indian Kanun. It is not reported.
Okay, but your friend doesn't seem to be able to locate it in India Kanun.
Yes, I will get back to this. He will try to
Unless
find
we
it out.
have that before us. What does it say? What does it say?
It's just because Malkhana register is not produced before the court is not fatal to the case of the prosecution. Mainly, that is the core issue in this. This is just 3 pages of writing. With Your Lordship permission, may I read?
Yes.
In paragraph number 3, it's written that the High Court, however, placed strong reliance on the defense submission of non-production of Malkhana register. On this ground, the High Court recorded that Malkhana register has not been tendered in evidence, and acceptance of oral statement of PW number 5 that the article were in the police Malkhana of plant site, police and nothing else is available on record would not arise. Significantly, however, no reason whatsoever has been ascribed as to why Malkhana register could not be produced, thereby posed the adverse presumption of the Evidence Act that in the event of its production, it would have thrown the sufficient light of the detriment of the respondents in the matter. The High Court in its order noted that even no official attached to the plant site station has been examined, so and so. Your Lordship, I'll just skip that part. I'll just skip this for a while. And that is the third and fourth ground. And fifth, and non-examination of the FSL officer. Oh, no, the JMFC. Your Lordship, in many cases, JMFC who have timed the inventory are not, however, could not be a missing link within the chain of evidence of the prosecution. Now, what is stated by PW number 1, 2, 3, and 4 are all in corroboration that the the appellant is in possession of the illicit drugs, the seized articles. So they have proved that. So the question of non-examination of JMFC could not be fatal, Your Lordship, because all the prosecution witnesses points towards the guilt of the accused only. And they have
Who has
proved
stated
the-
regarding the after the seizure it was deposited in the Malkhana? Is that the case?
Yes, PW number 4, page number 25, her cross-examination, para number 4.
Cross-examination,
In cross-examination, yes.
page 26,
Yes,
para 4.
page 20, para 4.
After submitting the information,
No, my lord, it's in chief. It's in a chief at page 25, para 4,
25, yes.
not in the cross.
during the process of weighing one of the went to attend, so I told him to present
Sorry, yes, it's page number
So
25,
done. I arrested
para
the
number
accused
4.
and seized the said contraband dunks along with the prepared seizure and arrest memo. And he also
So-
put his signature and brought the seized article and against to excise station. The same day that is article was kept in excise Malkhana. When was it produced before the magistrate? Seizure was
It
on
was-
18th.
Very next day, my
Yes,
lords.
the next day, 19th. The request for inventories.
Any challenge during cross-examination as to the proper custody?
No, Your Lordship, nothing in page number 26.
Anything about Malkhana register during the cross-examination?
No, Your Lordship. If Your Lordship would like, I can read it out. But
Yes, I have read.
nothing is
already.
there.
That's all right, we have read it. Yes,
Nothing
next
is there.
submission.
So I have covered all the points that my learned friend have raised, the 5 points. Your Lordship, with regards to my submission, the prosecution
No, you have
proved-
left out one point.
Your Lordship, that JMFC I have already submitted.
No, no,
JM examination.
No. This mismatch between the quantities of the drugs mentioned in the inventory and the FSL report.
Oh, okay. That I did not know taken as a ground.
No, this was the main contention.
Okay. When I asked in the morning, it was left out. Sorry, because it's not. When my learned friend was making a submission yesterday, I was not present, and this morning when I rephrased, it was left out. So Your
You
Lordship,
can't change the documents. What is there in the
Your Lordship-
inventory is there. You can only explain now how this occurred, differences. And I don't think you can do it on the spot right now.
Your Lordship, in page number 71, inventory is 331 grams, 3315 grams. Page 71. And list of samples drawn and FSL.
Go to page 73. From all the soap
73.
boxes, 3 samples of about 50 grams each.
It's milligrams,
Hmm?
Your Lordship, not gram.
MGS.
Yes, MGS, milligrams.
Okay.
So I'm a little bit handicapped here. If Your Lordship would permit, my learned friend can make a submission in this regard as to why
just clarify.
the didn't come up. Yes, clarify.
My lords, at page 73,
73 and 76. Go to 76.
76, yes.
Description of the exhibits down below. 24 exhibits.
Okay.
Look at the extreme left hand, the quantities are mentioned there, starting from 45 mg, 92 mg, 61 mg, 48 mg, all are different. Some are in excess of
50.
50, some are below 50.
Or the sample quantity.
Yeah.
Okay. Your Lordship, samples drawn. This is the problem that we have faced. Now, sample is drawn before the JMFC in open weighing machine. And then the weighing sample, the weighing machine that they have in FSL is different, which is compact. So in many cases we have
see
seen
the numbers, 24 samples were received by FSL. Inventory
Yes.
also mentions 24 numbers of samples.
Yes.
All are marked. See the
All are
marking
marked.
numbers.
15 milligrams, 3 samples, 45, 92, 69. So, Your Lordship, yes, as I have submitted before, this is in many cases the problem that the prosecution has faced, because it used to varies. It used to varies because of the different weighing scale machine.
Okay.
Now,
My
with
lords,
regards to that, what I would like to
sanctity-
submit is that.
Sanctity is thrown out of the window.
Yes, correct. But then, however, what I would like to submit is that the seized articles, intact marking, is all the
No,
same with.
different weighing machines may show some discrepancy, but that discrepancy has to be consistent. If it is 50 in one machine, the other will show 53, maybe 55. But that has to be uniform in case of all samples. How can it show less
Your
for
Lordship,
one
I
sample,
cannot answer
more
for the
for
machine,
another
Your
sample?
I cannot answer for the machine, but then what I can answer is that it was sealed before the JMFC, and it was marked, and the marking that was sent, the marking is the same with that of what was examined before the FSL. So that I cannot argue on behalf of the machine, because I don't know how the machine works. And however, what I can say is that sealed packed before the magistrate and the sealed matched. The sealed match. There could be some whatever machine is doing, it's doing it. But then the core issue is that the sealed pack was received. Your Lordship, mode in which parcel found to be packed in page number 76. Parcel consisted of 24 exhibits packed in paper and enclosed in paper envelopes sealed with wax seals. The seal impression corresponding to that forwarded. So what I would like to submit is that they have received the same seized articles, samples that was drawn before the JMFC in a sealed pack.
My lords, can I just interject, Miss Mary? My lords, at page 76. Your Lordships has it.
Is this the page 76 is weight of the drugs in the packed condition?
In the packed conditions, yes. Samples drawn before the JMFC. So that is why they are careful in saying that about, not exact weight. They do not say 2 milligrams, 5 milligrams, or whatever amount. They will say about. Because there could be some variation in the machine that is used. In every case. In the thousands, 10,000 cases that we have here in Mizoram, there will not be a single document wherein the list sample drawn before the JMFC and the FSL will 100% matched. So that this is just normal, Your Lordship, in my humble opinion.
Yes. So you are done?
And Your Lordship, so that is how I reply the my learned friend's submissions. With regards to the case of the prosecution, in my humble opinion, Your Lordship, the prosecution has proved the beyond reasonable doubt in as much as I'll start from 313 at page number 3, Your Lordship.
Which?
Page number 3, 313 examination.
Yeah.
So as to
Page
prove the
3.
Yes, page 3. So as to prove that the prosecution has proved the case of the appellant beyond reasonable doubt.
The 313 here, question 3.
Question 3, yes. It is in evidence that on searching your residence, they found a steel truck loaded with padlock in the storeroom cum bedroom. When she asked you to open the steel trunk, you replied to her that you were scared to open the trunk. Have you had anything to say? It is correct. And number 4, Your Lordship. On opening, they recovered 24 soap cases containing heroin inside the steel trunk, amongst some clothes. The said heroin was weighed at the spot so and so. What do you have to say? It is correct. Now, Your Lordship, what I would like to point out in question number 4 is that she knows that it contains heroin. The question was specifically containing heroin inside the steel trunk. She could have, if she did not know, she could have stated that I don't know whether I don't know the contents of the so and so deceased articles, but she knows that it was heroin. And 5 packing was done in her presence, and with I think my learned friend have taken Your Lordship thoroughly with all the evidence. So
Yes, yes.
So I will
Except
just, I
313.
will just, yes,
My
I
notes
will just,
313. My notes let me just clarify my notes. This question number 4. My notes, I will not say anything on vacuum, but my notes, the question itself is, it is in evidence. Now, she may have said it is correct, but your lordship may also look at question number 8 and question number 9. It is in evidence that the samples of the seized items were sent to FSL Azol and the report was positive for heroin. What have you got to say? I have nothing to say. 9, do you have anything more to say? The seized article in this case does not belong to me. I was asked by Purava to keep it for him. I kept for him inside the set steel trunk.
That may be
Yes.
so. Even
Yes.
the contraband may not belong to the truck driver. He may be carrying it for someone else, keeping it for someone else.
Agreed.
But that doesn't take away the fact of possession.
I agree, my lords, I agree. But
and
ultimately, my
your-
lords, the foundational facts, as per what is coming from the record, and the totality of facts, my lords, the sanctity, I don't think your lordships can just discard that, my lords. And the discrepancy in the samples recovered and what was sent to the FSL, my lords. And apart from the material documents, Malkhana register, my lords, Miss Mary had taken you to a 2002 judgment. Your lordships may just have
Your
this-
Lordship, my learned friend will have a chance to reply. This is not how we really conduct. I don't know why I got interrupted every now and then.
Oh. I'm answering a question from the bench, but Miss Mary may continue, my lords.
Not.
Yes. Yes, what else?
So may I
Have you not finished?
No, Your Lordship. I'm just going to point out that the case of the prosecution is strong enough that they have proved the possession beyond reasonable doubt. So I'm just starting only. Your Lordship, with my learned friend I believe that my learned friend have taken Your Lordship kind attention to the prosecution witness evidence, which starts from page number 18, Your Lordship. Now, from the evidence, we can see that we can see from PW number 1 that in the examination in chief, that in paragraph number 3, we went to the room just above the store, which is used as bedroom cum storeroom. There was a steel trunk with padlock. ASI asked for the key and they opened the said trunk in our presence. There were few clothes. There were few clothes. It is among that means it is there among the clothes. And 24 showcases inside the trunk containing orange color, power suspected to be heroin. And Your Lordship, if I may take Your Lordship kind attention to the examination in chief, it is in number 19.
Page?
So this is the Caesar witness who was not present when weighing, packing, and sealing of seized article was done. He mentioned in page paragraph number 6, admittedly. Now, what I would like to point out is that in paragraph number 10, the place of occurrence, that is storeroom cum bedroom of accused, was not easily accessible by the public. Now, I would like to just paint a picture of how this article is kept. It is kept in the bedroom, in the upper house, in the storeroom cum bedroom, inside a steel trunk that is locked, and the key was with the appellant. We have to know that the key was with the appellant. It was kept by her. I will come to that point. It was kept by her because the defendants have stated that it was kept inside that trunk by the appellant. It was kept by the appellant inside the trunk, locked it inside the trunk, she have hid it among the clothes. And if I may jump to page number 27. Page number 27 of the paper book.
Page?
This 27.
Yes.
Your Lordship, this is the evidence witness, the defense witness evidence. Your Lordship, this is her daughter. She have stated that
The son of the accused.
No, daughter, I think.
daughter.
Afro, Puya, Sri. Oh, that's the judge. Okay. Deposition of witness number 1. English language. Daughter of C. Vandlal Mwaka. Yes, what about that?
And Your Lordship, what I would like to state is that she have stated in the examination in chief that in para number 2 that at the time when Purawa have requested the luggage to be kept, she was present. However, her mother was not present. So that was what she was stated. And Your Lordship, with if I may take Your Lordship kind attention to page number 28. This is defense witness number 2. Paragraph number 2. This is their neighbor. And he have stated in paragraph number 2 that I was at the shop of the accused, Lal Engzawi, that is the appellant, while Purawa of western side of Mizoram came and handed over his luggage to Lal Engzawi. Lal Engzawi is the present appellant. Stating that I'll keep this luggage and it shall not be lost, and left immediately. Then Lal Engzawi took the same. So it contradicts, the defense witness contradicts itself. They have contradict, but what we can find out is that the seized article was inside their house, and this interested witness, this is defense witness, that is the daughter of the appellant, have stated that their mother was not there when Purawa have handed over the luggage. However, his neighbor who stated that they at the time when Purawa have handed over the seized articles to Lal Engzawi, and then Lal Engzawi, the article was found in the upper room or rooms cum storage of Lal Engzawi, which was kept locked, and the key was with the Lal Engzawi, that is the appellant. And PW number 2, page number 20.
DW, they are trying to, dislodge the premise of conscious possession.
Yes, the conscious possession.
They're trying to,
Is that-
defense is trying to dislodge the finding of conscious possession by way of this. That
Your
someone
Lordship,
else had put it in their place, they had no idea that this was heroin or whatever.
Yes,
was found.
however, Your Lordship, their house is like a store cum settlement house. So, as per the evidence of the DW number 2, it is not uncommon for the people to drop something because the shop is next to a sumo counter. However, Your Lordship, what we have to keep in mind is that, yes, it is not uncommon to leave some items in a person's shop to collect. However, we have to know that the seized articles have been kept in the upper room, that is the bedroom, in the steel trunk that is locked, not inside the shop that was. And then from the evidence of the PW number 1 para cross-examination para 10, it stated that it is not accessible, easily accessible by the public because it's now, in this regard, Your Lordship, with regards to the deposition of W number 4, this is the seizing officer's witness, evidence before the learned trial court. To prove the concierge position, I would like to refer paragraph number. First is the 313 question wherein you have stated that heroin was seized. Second is that PW number 1 and now defense number 2 witness deposition before the court, and now PW number 4 paragraph number 3. In the presence of civilian witnesses, an accused search the house was conducted by me. There was a steel trunk locked with padlock in the storeroom cum bedroom and directed the accused to open the steel trunk. She refused and stated that she is scared to open it. She then gave me the key of said trunk. So the trunk to that wherein the seized article was kept, the key to that was in the possession of the appellant, and she knows when they opened it in 313, she have admitted that it contains heroin. In this regard, Your Lordship, they have placed beyond, they have proved the case that she have possession as well as conscious possession of the seized articles beyond reasonable doubt. In this regard, Your Lordship, I would like to place reference on the 2025 SCC online SC 122. I'll start from paragraph number 14, Your Lordship.
What's the name of the party?
It's Rakesh
Raghuvanshi.
Kumar Raghuvanshi versus
Yes,
State
yes.
of MP. As a special act, ND&PS Act, that refers when the prosecution have proved the possession, the conscious possession of the petitioner, the appellant. Now, the reverse burden of proof falls on the appellant. In this regard, Your Lordship, with Your Lordship permission, may I read paragraph starting from paragraph number 14.
Yes.
Thus, before the court holds the accused guilty of the offence under the ND&PS Act, possession is something that prosecution needs to establish with cogent evidence. If the evidence is found to be in possession of, if the accused is found to be in possession of any contraband, which is narcotic drug, it is for the accused to account for such possession satisfactorily. If not, the presumption under section 54 comes into place. Section 54 of the ND&PS relevant in the context of is extracted. Now I'll jump. Paragraph number 16, Your Lordship. Therefore, as envisaged by the provision itself, unless and until the contrary is proved in the trials of cases involving offences coming within the purview of ND&PS Act, it may be presumed that the accused has committed the offence under the Act in respect of any articles prohibited to be possessed by him, and for possession of which he failed to account satisfactorily. Therefore, it is the burden of the prosecution to establish that the contraband was seized from the conscious possession of the accused, only when when that aspect has been successfully proved by the prosecution, the onus will shift to the accused to account for the possession legally and satisfactorily.
Yes.
I'll jump to paragraph number 20, Your Lordship. Same page, paragraph number 20. Section 35 of NDNPS Act deals with presumption of culpable mental state. It states that in prosecution under the NDNPS Act, the court shall presume that the accused have the requisite mental state, including intention, knowledge, and motive, unless the accused can prove otherwise. This shifts burden of proof onto the accused to demonstrate that they lacked knowledge or intent regarding the possession of the drugs. Conscious possession refers to a scenario where an individual not only physically possesses a narcotic drug or psychotropic substance, but is also aware of its presence and nature. In other words, it requires both physical control and mental awareness. The concept has evolved primarily through judicial interpretation, since the term conscious possession is not explicitly defined in the NDNPS Act. This court, through various of its decision, has repeatedly underscored that possession under the NDNPS should not only be physical but also conscious. Conscious possession implies that the person knew that he had the illicit drugs and psychotropic substances in his control and had the intent and knowledge of its illegal nature. And a discussion was made in paragraph number 223, wherein the apex court have held that when the prosecution have proved the physical possession, as then reverse burden would come into play.
Yes.
Yes. So what I would like to point out is that, Your Lordship, I have already to the 313, wherein she have admitted that the seized article contains heroin, admittedly, and then it was kept and locked in a padlock, and she have physical control over the seized articles because she gave the key to the seizing officer also. Now, all what my friend have taken as a ground, some technical errors, maybe allegedly technical errors. Now, Your Lordship, what I would like to submit before Your Lordship today is that as a human, we cannot be 100% perfect. Now, an agency, that is the prosecution agency, is also a human agency. We cannot expect 100% or a clear or a lucid picture of the agency or action done. Now, these are just minor defects which do not touch the core. Now, in our case in hand, the prosecution proved the case of the possession, unconscious possession of the illicit drugs of the appellant beyond reasonable doubt. Now, it falls on the accused to show as to why that seized article has come into her hand, her physical control. Now, she have adduced an evidence before the learned trial court, defense number 1 and number 2. There is there is contradiction I have already pointed out. That is not a minor contradiction, Your Lordship, and this is a major contradiction because how they have stated that the seized articles has come into their possession is totally different. So the defense witness evidence has to be rejected in threshold, Your Lordship, because these are major contradiction. Defense number 1 witness have stated that her mother, that is the appellant, was not present at the time of when seized articles was handed over by Purawa. And in their evidence, in the cross-examination, they have both stated that they do not have any intention or did not take any action so as to find out who Purawa is also and where he is. even though they put the blame on him. This is a major contradiction, Your Lordship. So it should be rejected in the threshold. So, I don't make that. Section 34, 35, and 54 would come into play, Your Lordship. With that, I conclude my submission.
My Lords, I think Miss Mary is done.
Yes.
My Lords, as amicus, my Lords, I just want to point out certain things. My Lords has...
But can you take this plea unless you put this question to the concerned witnesses, this discrepancy in FSL report and all those stuff?
I'm sorry, my Lords,
Regarding this discrepancy,
yes,
was there anything put to the prosecution witnesses
it seems
to
not.
account
my
for
Lords,
them?
It seems not.
Then can we take it up for the first time in appeal?
My Lords,
There is no scope for the prosecution to explain it now.
Your Lordships can always remand the matter just on this aspect because it is not a minor discrepancy. My Lords, the learned APP had read out the judgment in Rakesh Kumar Raghuvanshi. What the Supreme Court actually says is the burden of the prosecution to establish that the contraband was seized. My Lords, from the record it is clear, trunk has been found in her possession. What was found inside? The composition of that seized article. Was it heroin at the time of seizure? And was it heroin at the time of after, my Lords, sending it to the FSL? That is the only point I am raising. That is all. That is a very major element, my Lords, which is missing. And the 313
No, for that to happen, that was not what was recovered was not what was before the FSL.
Yes.
Then you have to prove some missing link in the chain of custody.
Yes, yes.
Where is that?
Now, my Lords, as
Except the non-production of Malkhana register.
and the test memo, my Lords. Test memo is very important. Your Lordships can just have Noor Agha judgment. 2008 16 SEC 417. And my Lords, before I just read out the relevant paras, my Lords, the 313 question and the answer to that, it is not an admission to the fact that what was found was heroin. She's not admitting. She's saying it is correct that you have apparently
That
found.
can be proved by other means.
Yes,
That what was found was heroin.
correct. My Lords, if I may take you straight to para 107.
As soon as she admits that stuff was recovered from me,
Yes.
and prosecution can thereafter prove that it was properly
Seized.
seized,
And
sent,
that what
kept,
was
sent,
seized, yes, yes.
examined.
Then the reverse burden
Yeah.
starts, my Lords. Para 107. my Lords. Lordships has it. This is also in regard to...
Yeah, para?
107. Lordships has it.
Yes.
The seal was not even deposited in the Malkhana, as no explanation whatever has been offered in this behalf. It is difficult to hold that sanctity of the recovery was ensured. Even the Malkhana register was not produced. Para 108. There exist discrepancies also in regard to the time of recovery. Recovery memo so and so shows that time of seizure was 11:20. However, PW2 stated that the time of seizure was 8:30. Appellant's defense was that some carton left by some passenger was passed upon him. Being a crew member in this regard assumes importance. Panchnama was said to have been drawn at so and so, whereas PW number 2 stated that Panchnama was drawn at 8:30. Exhibit PA containing the purported option to conduct personal search under section 50 only mentioned the time when the flight landed at the airport. Your Lordships may come to para 111. In a case of this nature, when there are large number of discrepancies, the appellant has been gravely prejudiced by their non-examination. It is true that what matters is the quality of evidence and not the quantity thereof, but in a case of this nature where procedural safeguards were required to be strictly complied with, it is for the prosecution to explain why the material witnesses had not been examined. My lords, I'm just taking you straight to the points I want to highlight, my lords. Para 99 also, my lords, the
So 107, then
108,
yes.
111, and your lordships may also have para 99 and 104 of the same judgment. Para 99 first, my lords, and 104. Para 99. Your lordships has para 99.
Yes.
We cannot but also take notice of other discrepancies in respect of physical evidence, which are: the bulk was kept in cotton bags as per Panchnama, while at the time of receiving them in the Malkhana, they were packed in a tin as per the deposition of PW5. Number 2, my lords, the seal which ensures sanctity of the physical evidence was not received along with the materials, neither at the Malkhana nor at the CFSL, and was not produced in court. Not exhibited at all, my lords, in our case. Forget about putting in the Malkhana, my lords. 104, my lords. The samples taken allegedly contain the signature of the appellant as also those of customs. So and so, my lords, your lordships may skip the part which the deposition of PW, but your lordships may just see it starts with however after the deposition.
No, but at the same time you must see
Yes.
that, for example, 106,
Yes.
cross-examination by so and so. I was not given sample seal along with the case property so and so. So that cross-examination part was there. That is why the higher courts could come to these findings.
Yes, yes,
But
but-
unless that foundation is laid,
Correct. Yes. Seal, my lords, the seal and Malkhana and the discrepancy which I think, my lords, they take of utmost importance. Ultimately, the foundational fact is what? You may recover a trunk, a bag, but what is inside and the composition of that substance, that has to be proved, my lords. Now I understand your lordships is taking this in appeal. That part, my lords, I leave it to your lordships' wisdom, my lords. These are material, my lords, and your lordships, I just point out one more judgment, which is Ragesh Jagdamba, 2005, 9 SEC.
yes.
Para 14, I'll just take your lordship straight to para 14.
9 SSC page,
2005, 9 SEC 773. Rajesh Jagdamba Avasthi. Para 14. Para 14, my lords. Your lordships has it? Para 14.
yes.
We do not find it possible to uphold this finding of the High Court. The appellant was charged of having been found in possession of charas weighing so and so. The charas recovered from him was packed and sealed in 2 envelopes. When the said envelope were opened in the laboratory by the junior scientific officer, he found the quantity to be different. While in one envelope the difference was only minimal, in the other the difference in weight was significant. The High Court itself found that it could not be described as a mere minor discrepancy. Learned counsel rightly submitted before us that the High Court was not justified in upholding the conviction of the appellant on the basis of what was recovered only from envelope A, ignoring the quantity of charas found in envelope B. This is because there was only one search and seizure, and whatever was recovered from the appellant was packed in 2 envelopes. The credibility of the recovery proceedings is considerably eroded if it is found that the quantity actually found by BW number 1 was less than the quantity sealed and sent to him. As he rightly emphasized, the question was not how much was seized, but whether there was an actual seizure, and whether what was seized was really sent for chemical analysis to the scientific officer PW1. The prosecution has not been able to explain this discrepancy, and therefore it renders the case of the prosecution doubtful, my lords. It is a very significant step, my lords, this discrepancy that has to be crossed and the foundation laid by the prosecution is my only contention, my lords. That foundational fact has to be proved. The witness may not have been cross-examined, but the burden never shifted, my lords. Ultimately, the High Court's conviction was set aside in that case, based on this discrepancy, my lords. And lastly, my lords, I'll just point out one more judgment.
Yes.
One last judgment, my lords. State of Rajasthan versus Gurmail Singh, 2005, Volume 3, SEC 59. Very short judgment, my lords. I just want to point out just one paragraph. Para 3 of that. Your lordships has it? Para 3.
Yes.
Citation is 2005, Volume 3, SCC 59.
Yes.
Para 3, my lords. We have perused the judgment of the High Court. Apart from other reasons recorded by the High Court, we find that the link evidence adduced by the prosecution was not at all satisfactory. In the first instance, though the seized articles are said to have been kept in the Malkhana on 20th May 1995, Malkhana register was not produced to prove that it was so kept in the Malkhana till it was taken over by PW6 on 5th of June 95. We further find that no sample of the seal was sent along with the sample to the excise laboratory for the purposes of comparing with the seal appearing on the same bottles. Therefore, there is no evidence to prove satisfactorily that the seals found were in fact the same seals as were put on the same bottles immediately after seizure of the contraband. These loopholes in the prosecution case have led the High Court to acquit the respondent. High Court's judgment was upheld.
Where is the examination of the FSL expert?
My lords, he was not examined.
He was not examined.
Yes, my lords. A judgment also marks it, the impugned judgment, at page 31. Your lordships has it. Relevant part is page 32 at para 5. He was exempted, not called for evidence, as no dispute on expert opinion.
So defense considered
My lords, consider.
there is an order dated 12/10/22
Yes.
dispensing.
Yes.
The scientific expert 293 he can if it is accepted then it can be waived.
My lords, definitely. I admit to that, my lords. But still, my lords, even if it's what is the expert
So
opinion?
that is why we are
that part, that link,
returning back to the
yes, to the seizure.
trial court, to the cross examination. If you at that time you do not raise any objection to that and appeal, you come and point out all these discrepancies.
Fortunate, my lords, the defense counsel did not point that out. As amicus, my lords, this is the only part that seems to be unanswered. But my lords,
What we have only is the report of the FSL. We do not have his deposition, whether the
Correct.
seal was there, whether everything. We don't have his deposition now. Only the report is
my
there.
lords, I've seen the LCR. There is no deposition also. There's no deposition in the LCR also.
Obviously, there will be no deposition of the FSL expert if he is not called.
So, my lords, my only point is either you prove it through that particular scientific officer, you figure a way out. Anyways, the burden is still on the prosecution.
Burden is on the prosecution, but we will not be given any advantage due to non-examination of the FSL expert.
No advantage, nor, my lords, I would say disadvantage.
It says the seal impression corresponding to that forwarded, so that part is there.
But, my lords, the seal has to be exhibited ultimately. The seal was never examined, produced by the seizing officer. There's a huge loophole there, my lords. And the date when they received it is apparently on 26 March. 18th March was the seizure. And the test memo, my lords, as per the 2022 seizure storage rules, is a very important Form 6, my lords. That is not exhibited, nor has it been made in this fact, in this case.
Yes.
My lords, apart from that, I'll conclude with that, my lords.
Yes. CAB.
My lords, my presence may just be marked as amicus. because-
Amicus, yes. Being as amicus. Miss. Ask them to get printouts of these citations. Okay? Don't print out copies. You need the books.
Would you be obliged?
Obliged.